A Canadian-based oil firm, Africa Oil BV Kenya, has suffered a major setback after High Court Judge Justice David Manjanja upheld 2.2 billion shillings tax demand by the Kenya Revenue Authority against the firm. Effectively, High Court allowed KRA to demand the arrears from the oil and gas exploration firm in and paid taxes for selling oil blocks in Turkana fields. In a judgment delivered yesterday, the High Court dismissed an appeal by Africa Oil Kenya challenging the Tax Appeals Tribunal's decision, which endorsed KRA's demand. The court agreed with the tribunal's decision, which was also KRA's position that the farm-out agreement is structured in a way that Africa Oil Kenya retains an overriding reversion ally interest in the farmed-out area of payouts. The dues that the foreign company owes the taxman arise from VAT on farm-out transactions from 2011 to 2017. Farm-out agreements, which are common in the oil and mineral sector, are where an owner of a project cedes part or whole interest to a third party for development. KRA says Africa Oil Kenya BV earned income for ceding part of its interest to Tullow Oil, Marathon Oil and Maersk Oil of oil blocks in northern Kenya and never paid the VAT. However, the firm has expressed intention to appeal the High Court decision. Justice Manjanja dismissed an appeal filed by the oil firm challenging the decision of the Tax Appeals Tribunal, confirming the KRA's demand for unpaid taxes. The tribunal had observed that the company, being in the oil and gas business with interest in various oil and gas exploration blocks in Turkana, had entered into farm-out agreements for the various oil blocks where it assigned its rights to other companies and received income from them. The company had stated that the said farm-out transactions were a sale of its business and not a taxable supply subject to VAT under Section 2 of the VAT Act 2013. Tullow has a 50% stake in the Kenya project, while Africa Oil and Maersk each own 25% of the two blocks where discoveries were made in 2012. KRA carried out a tax audit of the company's tax affairs in the year 2017 for the years of income 2012 to 2017 in respect of corporation tax, VAT, pay-as-you-earn and withholding tax. The audit also included a review of its farm-out transactions where the company assigned its exploration rights for Blocks 12A, 13T and Block 9 to third parties such as Tullow Oil, Marathon Oil and Maersk Oil in 2011, 2012 and 2017. It was the position of KRA that these farm-out agreements constituted taxable supplies and thus ought to have been charged VAT. The tribunal, in agreement with the KRA's position, stated that a farm-out is a supply of a capital asset and that supply of capital asset is a taxable supply in accordance with Section 5(1) of the VAT Act. Africa Oil Kenya BV was agreed by the decision taken by the tribunal and appealed to the High Court. In the judgment, the court allowed KRA to collect 2,293,334,065 from the company, being unpaid VAT for the years 2011, 2012 and 2015. Reporting for The Informer, Catherine Chalo.